Kenya, the East African community and the whole world. Today, we are standing here having filed a serious application outside the jurisdiction of this country because of the failure of the Kenyan courts to grant our client, Governor, His Excellency Mike Sonko, his rights. The violation of his fundamental rights has necessitated us to move outside the Kenyan jurisdiction, and we shall lay the basis as to why we have taken that unprecedented action which indicts completely the judiciary of Kenya, whereby we have laid bare the type of fraud, the type of forgery, the type of total disregard to the rules of procedure and rules of evidence that led to Governor Sonko being condemned and heard and condemned without being given a fair chance to represent himself. My good friend Mr. Wanyange will lay blow by blow the grounds under which we have been forced to go to the East African Court of Justice so that Governor Sonko can get justice like anybody else in this country. Council Wanyange.
Members of the fourth estate. It's unfortunate that we have been constrained to seek justice outside the borders of Kenya over issues that we have otherwise been handled by the judiciary arm of the party. The Honorable Governor, as all of you are aware, was impeached by the county of Nairobi that lacked quorum, that was forced to be able to, through corruption and other issues, be able to ensure that he doesn't get back to his office by dint of political mechanization. We have seen the arm of this political mechanization follow our clients' pursuit of justice in the judicial corridors. And most recent, the situation that happened at the Supreme Court that is unprecedented when a matter that is supposed to be substantively heard is given unreasonable time frames outside the rules that is the Supreme Court itself is governing. We have, pursuant to the decision that was rendered by the Supreme Court over this matter, identified various flaws all the way from when this matter started before the judiciary and how it was handled, even with a judicial officer presently facing the Judicial Service Commission over his conduct touching on this matter and other matters that are akin to this particular matter. And all these facts are within the knowledge of the judiciary, and all these facts were within the knowledge of the president of the judiciary of Kenya, notwithstanding the fact that these matters were brought to the attention of the judiciary, and matters that touches on the process under which Governor Sonko was impeached and the laws that were followed, which were flawed. They have chosen to look the other side and sacrifice the political rights, sacrifice the rights to be heard of our client Governor Sonko. By dint of their actions, we, as earlier on indicated, are constrained through a team of lawyers, some who are here, and some who are presently handling a matter touching that has a bearing equally in this matter in Mombasa, constrained to file a reference before the East African Court of Justice. And together with the reference, we have equally filed an application seeking interim reliefs pending the hearing of the reference, which will be heard in due. And members of the Fourth Estate will have an opportunity to look at the documents that have been filed. We are fortunate that the registry of the East African Court of Justice is evolved, and as such, these documents are now public documents that can be accessed by members of the Fourth Estate as when they require. I cannot go through an entire document like this blow by blow, but you'll be able to pick whatever you need that is properly articulated in the document.
As my good senior has indicated, 13 grounds appear very pertinent in the Governor Sonko's petition. First one, the punishment provided for an impeachment is more permanent than it is in any other offenses. That once somebody is impeached, he cannot hold a public office. You know very well that is a punishment in eternity. Murder, capital sentences under Muruatetu have been reviewed. The purpose of a punishment is to rehabilitate. The Supreme Court was supposed to look at this matter and go deeper to the merits that the process of impeachment at the Nairobi County Assembly was flawed. It had no quorum. It was a political process. It was one that was aimed to replace Governor Sonko for the purpose of NMS to come on record. That was ignored by all the courts, and they insisted on checking that process, which they have sanitized, where every Kenyan knows that Governor Mike Sonko had the majority of the MCAs, yet the process was flawed. Nobody has raised that question. Number two, after the flawed process that removed Governor Mike Sonko, the same process at the Senate was completely flawed. Governor Sonko raised the question that he was never given a fair chance to defend himself at the Senate. That was ignored. Third, for the first entry into the judicial process, the court that dealt with this matter, one Justice Chitembwe, has been suspended. Reasons being that Governor Sonko raised a petition challenging the integrity of that judge. The same JSC suspended him, and he is facing a tribunal appointed by the president. That was laid bare before the Supreme Court, that under the law, under the Supreme Court decisions by themselves, they have said that if a judge who has had a matter is removed on the basis of abuse of office or integrity, that matter should be remanded back to that same court with a different judicial officer to determine that matter on merit. That ground was never considered. That is the third ground. On the fourth ground, Governor Sonko filed a petition that before the Chief Justice, and the Chief Justice herself appointed 3 judges to sit in Mombasa and hear the matter. On the same date that the matter was proceeding in Mombasa, the same date the Supreme Court was proceeding with Governor Sonko's matter. The lawyers, who then on record with us, wrote a letter to the Chief Justice and to the Supreme Court indicating that you know very well you have allocated us this matter to proceed in Mombasa. We cannot be available in Nairobi at the same time. Governor Sonko must be present in Mombasa. He can't be present in Nairobi. That was ignored. That is the fourth ground. The fifth ground is that when this matter was coming before the Chief Justice, the directions issued first were that the matter will proceed on a specified date, without due regard to taking directions. The procedure worldwide is that any civil matter, before it is allocated for hearing, there must be directions. Our colleague, Mr. Nyamu, wrote back to the registrar and to the Chief Justice that this matter is not ripe to be heard. The respondents have not filed their responses. How will a matter proceed and the respondents have not filed their responses? A letter that we have annexed in the petition, the Supreme Court registrar writes back to Sonko apologizing that, oh sorry, we apologize, we had not even looked at that this matter, respondents had not filed their matter. This is the Supreme Court apologizing and says we will give now new directions so that the respondents are given time to respond. That's ground 5. The sixth ground is that still after the Supreme Court apologizes to Governor that this matter needs to respond, it goes ahead and fixes the matter for hearing, regardless of them admitting that there is no responses by the respondents. Matter, seventh ground. The Chief Justice, in a public function in the prayer day and on a radio station called Spice, comments on this matter and says very clearly that anybody who has been impeached stands impeached unless it is reversed. That was a matter that she was going to preside over. She makes a public utterance of a judgment before the real judgment is given. Governor Sonko files an application for her to recuse herself. That application for recusal is dismissed. Remember, Governor Sonko is alive to the fact that the question about a judicial officer raising her opinion or his opinion before the matter is before you for determination is so prejudicial to Governor Sonko. That was ignored. The application for recusal was rejected. The directions, number 8, comes that a 5-bench judge, we have given you a copy of the order by the Supreme Court that the matter for Governor Sonko will be heard by 5 judges. Court order is there. Come the date for hearing, there are 7 judges. The orders saying that there will be 5 order judges was never revoked. Governor Sonko and his team raised that question before the court. How can you tell us it is 5 judges by court order, then again you are sitting 7 judges? A greatest violation of the fundamental human rights of Governor Sonko was occasioned by that sitting. So the question we are raising, what prompted a full 7-bench judge when directions are issued that there are 5 judges? Still, number 8, after that has been done, this matter was filed way back in March. at the Supreme Court. At the IBC tribunal, it was rumored that Governor Sonko did not file an appeal. And it was a process that was being cooked within the registry until Governor Sonko produced Safaricom payment receipts, M-Pesa payment receipts, everything that was done online until the court agreed that he had filed within the timelines. 8. The decision in Mombasa is done on 12th, allowing Governor Sonko to be put in the ballot. On 13th, sorry. Immediately, the decision in Mombasa that put Sonko in the ballot, the Supreme Court immediately issues a hearing notice for 14th. This matter was before the Supreme Court way back from March this year. It had never moved. But the decision of the Mombasa Free Judge Bench jolted the Supreme Court to react, firefighting, slotted the hearing on 14th. The duration as to why this matter was never determined from March to the 13th of July raises serious fundamental questions. Point number 9, the Supreme Court on 14th proceeds now to hear this matter. Serious protestations from the councils defending Sonko. This matter, directions have not been issued, respondents have not responded, and also, even if they respond, Governor Sonko must be given the right for a rejoinder. That was denied. Governor Sonko's petition proceeds on 14th, and a judgment, a ruling is issued same day. Next. What was the urgency? What was the urgency in this matter? The urgency of this matter, our client instructs us to say, and we are without a blink of an eye, that the speed at which the Supreme Court decided this matter was purely for politics to stop Governor Sonko from being in the ballot. He reads malice, he reads political machinations, he reads a lot of forgery and a lot of issues within that decision. Point number 11. Based with these facts, are they violations of his fundamental human rights? Article 38, which provides of the Constitution, which provides for the political rights, have been buttressed by Article 2, sub-Article 6, that says any treaty or any convention signed by Kenya becomes a law of this country. Therefore, we have gone to seek justice in the East African Court of Justice, which, from President, Senior Counsel, Her Excellency Mother Karua, when agreed with the decision of the Supreme Court, because of not being a fair hearing, went to the East African Court of Justice, and the Supreme Court, by extension, the Kenyan government, was found to have flouted the fundamental human rights, Mother Karua. Therefore, we have a president, and that is why we are going that direction. The last issue, the judgment, the ruling of the Supreme Court, which has never happened anywhere, the Supreme Court admits in writing that that matter, they had no jurisdiction. Everybody will read that. The Supreme Court has admitted it has no jurisdiction. Yet it goes ahead to hear and issue draconian orders. Every law student knows very well, jurisdiction is what confers a court power to proceed The question of jurisdiction is admitted. They don't have jurisdiction. Therefore, what is the basis of these other orders? Because they could have ended at that point. So, Governor Sonko has gone to the East African Court of Justice to demand that a court without jurisdiction cannot issue orders at all. Appeal, a preliminary objection on jurisdiction compromises a matter. In total, you can't move a step. How did the Supreme Court move ahead to hear this matter? If there is anybody that has been his rights have been violated completely, is one Governor Sonko. Remember, the decision of the Supreme Court, if it is upheld, it is a permanent imprisonment for Sonko, that he can never hold any public office till he dies. Probably he can go to get another public office in heaven, but in this world, he can't. It is such a grave question. It is not a light matter that destroying one's career permanently. Governor Sonko does not know any other profession other than the profession of politics. So that is why we have decided that we will move to the East African Court of Justice. Still, there are more layers. The international arena has very many courts that will get reprieve, because this is about a career. And unless the Supreme Court is checked on this matter, we are not going to agree. Remember, the Supreme Court did not vacate the orders of the 3 judges at the High Court in Mombasa that allowed Governor Sonko to be in the ballot. What, right now, as we stand here, this is a candidate for the Mombasa gubernatorial seat. We have launched a review at the Supreme Court. We have also launched a matter in the East African Court of Justice. What does Article 99 free 4 say? That only Mike Sonko be stopped from being in the ballot if all avenues of appeal have been exhausted. The appeals include review. That IBC should take that judicial notice that still there is a review if the Supreme Court, there is an appeal in the East African Court of Justice. He cannot be stopped from being in the ballot until the review decision comes out and the appeal decision comes out, making him not be available. We strongly believe the East African Court of Justice will not be manipulated to sit and make that decision tomorrow, because that is a court that encompasses every aspect of the region. Sonko, as he stands here, is leaving now to go and campaign, and he leaves his legal team to battle with the issues that we have raised. So remember, we have only highlighted 13 grounds. The petition has more than 30 grounds on which he has put across that shows clearly that Sonko is being politically harassed. Reason being that he came to Nairobi to campaign, and he has been in Mombasa to campaign for the Azimio wing of the political arena. Let this serve as notice. Governor Sonko and all his team are prepared to ensure that no any other Kenyan will face the type of vilification and the type of hounding that Governor Sonko has been exposed to, simply because he has a different opinion. He should also be protected under the law. The Constitution provides in Article 27 for equal protection for everybody, whether a foreigner, whether a former governor, or a candidate in the governor's seat. So those are the instructions we have from Mr. Sonko, Governor Sonko. He will not be able to talk. He's completely overwhelmed of why are these matters taking this time. We can take 2-3 questions from the members of the press. The legal team will be able